everybody's attention. We're going to start court, please.
Hey.
At this time, let the record reflect all 15 jurors have returned to the courtroom. Everyone may be seated. Counsel, do you waive the call, or do you wish for me to do roll call? Waive. Mr. Wool, waive. Okay. Mr. Young, are you ready to do your opening statement?
Yes, sir, I am.
Proceed when you're ready.
Yes, sir. Hey, please report. Defense counsel. May I please report?
Yes.
Ladies and jury, it's time to get down to business. This is what we're here for. And what we're here for is the disappearance of Crystal Rogers. Crystal Rogers was last seen on July 3rd of 2015. She's the daughter of Tommy and Sherry Ballard. She was born in 1980, was 35 years old at the time that she disappeared. She disappeared late in the afternoon of July 3rd of 2015. It was on a Friday evening. Her daughter, Kylie, was the last person out of anybody indicted in this case to see her alive. Kylie was at home waiting on the grandmother to pick her up when she left with Brooks Howe. She had 5 kids: Ashley, Kylie, Tori, Trenton, and little Eli. Eli was about 2.5 years old. Eli was the baby of Brooks and Crystal. Crystal was living with Brooks in Glenview subdivision, and she also worked for him. She was still married to Keith Rogers, and you're going to hear testimony that Keith nor her could afford to get divorced. Crystal's car was found abandoned on mile marker 14 of the Bluegrass Parkway on the late afternoon of July 3rd, 2 days after she was last seen. To this day, she's never been heard of nor seen. She's been missing. Crystal's car, as I told you, was left on the Bluegrass Parkway. This is Bardstown over here. The Bluegrass Parkway runs between Elizabethtown and Versailles, Kentucky, Lexington. She was towards Elizabethtown, westbound, on the westbound lanes, going towards E-Town at mile marker 14. Her car had a right rear flat. And then you'll see pictures where they'd driven on the road with the flat for a little while. In her car, there was a cell phone, her purse, and her keys in the ignition. That was the only signs, only personal items connecting her with the car being out on the Bluegrass. Brooks Howe. He had a 2.5-year-old child, Eli, with Crystal. He and Crystal lived together. He builds houses and also has a rental house business. He was the last person to have seen Crystal Rogers. Polly was the last person who's not been indicted to see when her mom left that night with Brooks. The defendant was working for Brooks' house. Steve Lawson, the defendant, was working for Brooks' house doing bobcat work. He worked for Brooks' house. He was married to Tammy Lawson. You're going to hear testimony from some of the other workers, some of the other people, that there was some unusual behavior going on, something out of the ordinary that they normally don't see from Brooks' house. He was riding around the truck with a worker, this man who had just began to work with him. You're also going to hear that on July 4th, right after midnight, into July 3rd, into the 4th, about 7 minutes after midnight, there was a 13-second call from Steve Lawson to Brooks' house. Steve Lawson hangs up that phone, and you see his phone start moving. And it drives to approximately the 14-mile marker on the Bluegrass Park, where Crystal's car is. Steve Lawson's son, Joseph Lawson, he was also an employee of Howard. Before Steve Lawson called Brooks, he had received a call or talked to Joey Lawson. Talked to him for 2 minutes and 58 seconds. Hung up from Joseph Lawson, and that's when the 13-second call was made to Brooks' house. And you're going to hear his explanation, multiple explanations, of what that phone call was about. Rosemary Howard. Rosemary Howard was Brooke and Nick Howard's mother. She lived on the farm, and you'll hear that her and Crystal didn't get along very well. The plan. The first week in July, there was unusual activity that I told you about. Steve Lawson riding around with Brooks' house. Brooks doesn't ride around with employees. There was one employee he rode around with, son Danny Singleton. But it was unusual, you're going to hear, for him to be riding around with an employee that week. Usually he would stop, drop off nails, drop off whatever equipment they needed, and move on to the next house. According to the defendant, he had just began working for Brooks' house. There was one worker named Stacy Cranmer. Stacy worked with a guy named Kenny Girdley. They built decks and done insulation for Brooks. She thought this was odd. She'd been watching this go on. So she decided she's going to ask him about it. She said, "What's up? What are y'all doing? Why are you riding around with me?" The defendant's words were, I was talking to Brooks about taking care of a woman with 5 kids. A woman, Crystal Rogers, who has 5 kids. Taking care of can mean a lot of things. But I think it'll become apparent to you what it was by the end of this trial. The defendant is asked by Brooks' house, "I want to get rid of Crystal." You'll hear the defendant tell you that means gone, dead. The defendant saying, "I can't do that. I won't do that. But I will help you by moving the car, staging the crime scene." See, they wanted to look like Crystal left. Just got up and left. So they had to move the car. That's the man right there that moved the car. That's the man right there that aided and conspired with Brooks' house. The evening of July 3rd, 2015, Brooks takes Crystal on that fatal drive to the farm. According to the defendant, he and his son went, after they left the house, after Kylie had left the house, they go to Brooks' house. They go to Brooks' house and take the car. son, traveling down the Bluegrass Highway, was taking the car, according to the defendant. This is the defendant's own words. And got a flat tire. That was the reason for the 2-minute and 58-second phone call shortly or right after midnight between the defendant's son and the defendant, which precipitated a call to Brooks' house that lasted 13 seconds, long enough to tell him that Joey's broke down in the Bluegrass, I'm going to go get him, or, if you believe the defendant's words, the job's done. According to the defendant, that part of their plan, their job was complete at that point. Crystal never heard from again. After 9 p.m., Crystal does not respond to any text, any calls from anybody. Her kids are texting her, her mother's texting her. There is absolutely zero response. Over the weekend, her mother and children continue to attempt to get a hold of her, and those calls went straight to voicemail and unanswered. Her phone was off. Her mother reported her missing on July 3rd. After speaking with the defendant, Brooks Howe, at a gas station. In the afternoon of July 5th, she's like, have you seen Crystal? No. Well, we've been trying to get a hold of her. Nobody can get a hold of her. She goes, I'm going to go report her missing. He told her, yeah, why don't you go do that? I think that's a good idea. The Nelson County Sheriff's Office began an investigation that afternoon. Sherry went to the sheriff's office. You're going to hear that Sherry went to the sheriff's office. She was frantic. So frantic, they called in the detective. Something they usually don't do on missing persons. But they called in the detective. And shortly after they called that detective in, they find her car abandoned on the Bluegrass Parkway. Hal's story was that she was gone when he woke up Saturday morning. Left the baby with him. Hal attempted to call her a few times over the weekend, but it went straight to voicemail. Meanwhile, he attended a cookout on the 4th of July. Detectives, they requested the call detail records. Call detail records are your cell phone records to see who he talked to. Lo and behold, they noticed that 13-second call shortly after midnight from 502-492-1390, the defendant's phone number. Brooks Howe was brought in on an interview on July 8th. Question about that early morning call from Lawson. Howe states he doesn't recognize the number, so let's just call him. You're going to hear the call. They dial the number. He goes, oh, it's Steve Lawson. Steve Lawson's an employee of mine. Working. The defendant answers the phone and advises that he had called about renting an apartment. Renting an apartment for his daughter, Lauren, during that 13-second call. And you're going to hear from Lauren. And you're going to hear she was looking for an apartment. Police attempt to make contact with the defendant. He advises that he's not coming in and he's not turning over his phone. Police get a search warrant for the defendant's phone. They seize it from him on August 14th. The defendant, he comes in on interview. Comes in for an interview on August 18th, 2015, where he advises the detective that he doesn't remember the call that happened. Which the detective finds a little odd because on July 8th, he obviously remembered the call because he had told Brooks about what the call was about. But when he's brought in and interviewed by the police, he doesn't remember the call. The defendant advised he never left his house on July 3rd. He was home the whole night, drinking, didn't leave the house. Over the next 10 years, the defendant is interviewed multiple times and gave various stories about if he was on the Bluegrass Parkway and why he was on the Bluegrass Parkway at a particular location and time. In the end, if we believe we've proved the case beyond a reasonable doubt, we'll come back and ask you to hold that man right there responsible for agreeing to help Brooks out with his plan to murder Crystal Rogers. Thank you.
Does the defense wish to give its opening statement or
It
reserve?
does, Your Honor.
Proceed when you're ready.
Thank you. It please the court, counsel for the Commonwealth, Mr. Lawson. And of course, ladies and gentlemen of the jury, I'm going to move this, Your Honor. I'm not comfortable with that. As you folks have heard, opening statement is an opportunity for the parties to give basically what they believe the evidence is going to show. And you have heard from the Commonwealth, and the Commonwealth has put a plethora of information on that screen. And I saw jurors taking notes related to what was written on that screen. You can take notes about anything you want, of course. Just remember this: opening statements are not evidence. They are merely a statement from a party claiming that they know what the evidence is going to show at the end of the day. And they're trying to give you a roadmap of what they believe that evidence is going to show. I'm going to tell you that there are many things that were stated on that screen that you will not see. There are many things that were on there that will not be presented to you as evidence. Here's what we have in this case, folks. It's quite simple, okay? In a way it's simple, in a way it's extremely convoluted, okay? What we have, and I think that you're going to see, that this case, at the end of it, there's going to be something that's established. And you might think, you know what, what's the defense attorney who's representing Mr. Lawson telling us this? I'm getting ready to tell you something, okay? I'm getting ready to tell you that at the end of this case, you are going to be able to, with good conscience, look at the jury instructions and determine that Steve Lawson is guilty of one thing. And that one thing that he's guilty of, he is guilty of tampering with physical evidence. If you remember, when you were here at the beginning, the judge talked to you about there being two charges. The first charge was tampering with physical evidence. The second charge, of course, was the conspiracy to commit murder. You will not hear evidence in this case that comes anywhere near the burden of proof. That rock that I talked about before, that rock will not move from that table to that table in relation to the conspiracy to commit murder. You're going to learn over the next few days how the Commonwealth has created a narrative. It's a narrative. We've heard creating a narrative, right? It's what you want people to believe. And in this narrative, they're creating something because there's a problem. There's a problem that they need to create a solution for. And what is that problem? That problem is, where is Crystal Rogers? What happened to that poor woman the night of July 3rd going into July 4th? That's what this case is about. It's the Commonwealth trying after 10 years of investigation. Think of that, 10 years of investigating this. They now believe that they have all the information that they need to present to you to solve the mystery of the disappearance of Crystal Rogers. That's not what you're going to hear over the next week. That's not what you're going to hear. What you're going to see is a series of individuals that are going to get on the witness stand and are going to attempt to be heroes. Quite frankly, I don't have another word for them. Okay? They want to go down in history as people that have solved what has been called in the Commonwealth of Kentucky like the greatest mystery in the Commonwealth of Kentucky. And I know you folks haven't listened to anything, and we've cleared that out. You all probably not watched the podcast or anything, but trust me, This has been characterized as the greatest mystery in Kentucky legal history. The Commonwealth has decided that now's the time to solve it. Now's the time to be the heroes. In order to become the heroes, they have to put on evidence, right? And the evidence that they're going to put on, as we talked about briefly during voir dire, you're going to hear from many people who were investigators, okay? And these investigators, you're going to see, most likely through cross-examination, not direct examination, you're going to see the extent and the length that the investigators went through when speaking to witnesses in this case in order to scare them, intimidate them, to get them to say things that were not factually accurate. Why? Because they wanted to solve the mystery that we all want to know what happened. Where is Crystal Rogers? So you're going to see these investigators and what they've done to get us here today. You're going to hear also, through these same investigators, about a grand jury process like no other in the entirety of the Commonwealth of Kentucky. You're going to hear that over the past 10 years, we talked about a grand jury briefly in our voir dire process. 4, not just 1, not 2, not 3, but 4. 4 grand juries were impaneled over the past 10 years. In those grand juries, they didn't meet just one time. They met over 20 times. Count that, 20 times, where evidence was presented to them. And as you remember from voir dire, who doesn't get to present evidence? The defense doesn't present evidence, right? It's all about the prosecution. So 20 different times they met. 20 times they met before, with that low burden that we talked about before deciding to charge this man right here with conspiracy to commit murder. Not only are you going to hear from individuals who wear the gun and the badge, but you're also going to hear from some what I would call lay people. And these are people that basically are witnesses that they're not law enforcement. They weren't set to investigate the case. They may have heard something, they've seen something. And as you hear these people, I want you to just keep in mind, we are talking, for the most part, we are talking about things that happened 8, 9, 10 years ago. When you watch these people on the witness stand and they testify to you and they act like it happened yesterday, just keep in mind what you're listening to, okay? And keep in mind the dates in which these folks are talking, all right? And what you're going to see is that while the Commonwealth wants to act like it happened yesterday, they're doing a switch on us here, okay? They want you to believe that the witnesses that get up there and testify like it just happened. Like it just happened. Just keep that in mind when you're listening to this evidence. Okay? And not only are you going to see what they've done to certain witnesses, but you're also going to see that there were many, many, many leads that were never, ever followed up on. There were many pieces of evidence that weren't tested. There were many pieces of evidence that if they were tested, they were then turned over to people that weren't inside the law enforcement community. You're going to hear about a series of I believe at the end of it, you're going to say, how in the world did they present us this evidence and want us to believe this with the understanding that this investigation was so flawed? The other thing that you're going to hear, guess what's not over? Guess what's not over? And I'm not talking about just the trial of the 2 people that are going to go to trial later on in June. I'm not talking about the co-defendants. I'm talking about the investigation in this case. And what you're going to hear from the Commonwealth's own witnesses is that this investigation is still ongoing. It is still ongoing. Well, you may say, you know what, of course it's still ongoing because we don't know what happened to Crystal Rogers. Okay, I'll give you that. However, if there is a still ongoing investigation, how does the Commonwealth go to a grand jury and impanel that grand jury to charge a man with a Class B felony? I would think, and I hope the jurors would as well, before you charge somebody with something like that, you better darn make sure that you've completed your investigation. You better make sure that you've completed the investigation. And you know what? Here's the thing. I am not a person that is not sympathetic to Crystal Rogers and her family. Quite the opposite. I'm very sympathetic to them. Okay? Very sympathetic. The problem is that in this case, what you're going to see is that the Commonwealth has taken and basically, well, I would call him a scapegoat. He's not a scapegoat, okay? What he is, he's a person that has a portion, just a portion of involvement in this case. He's got that portion. And I just told you, and we're going to tell you again in closing, he's guilty of that. We own that. He's going to own it. We all own it. But he is not guilty of the larger conspiracy to commit murder of a person that, quite frankly, we don't even know where she's at. We do not know. We don't know the answers to it. And it's terrible. It's terrible. And I don't know what to say other than we do not prosecute people under these circumstances and try to attempt to put them in jail unless we have more answers than we have now. What I think this case is going to show, beyond what I've already said, there are more unanswered questions than there are answered questions. Okay? You're going to hear a lot of speculation and a lot of, we think maybe this happened, we think maybe that happened. Speculation has no place in a courtroom when we're talking about depriving a person of their liberty. We leave that at the door. We leave that for people who are doing crime scene television shows. We leave that for LA, okay? We don't bring it in here. That's not where it belongs. We covered reasonable doubt before, so I'm going to skip right over that with one comment. Of course, reasonable doubt, as we briefly talked about, highest burden. Highest burden in the criminal justice system, right? Far higher than burden in a civil case. Remember where the rock starts. Remember where that rock starts. Do not move it over there until they bring in evidence that supports the movement of that rock. What you're also going to hear, which Mr. Young alluded to in his opening, is that the guy sitting here in the blue shirt, he cooperated with law enforcement and almost everybody at that table. He had conversations with almost everyone there over 20 times. When you count what he did at the grand jury, and you count what he did when discussing things with all of these people.
You may. This bench conference button's not working. Can you do it down there? I'm catching bench conference. It's not working. Tell me who's at this button. See if I can James coming.
There you go.
There you go.
Judge, they invoked 410, and they're up now talking about the interviews that were conducted.
And talking about us in plea negotiations. That's exactly why
That's
we're
why we
having
don't
separate
do.
trials.
Go ahead. I didn't mean
That's
to cut you off.
exactly why we're having a separate trial. We're talking about plea negotiations and the prior interviews.
Judge, he just talked about in his opening that Steve Lawson made multiple interviews
did, and
and
it's-
multiple statements, and that he lied and he misleaded.
We have
If I'm not allowed,
absolutely zero, if anything from anything with law enforcement, when we were talking to him, anything from 2023, with the exception of the grand jury, that was the court's order on this.
well, here's the deal. And I know this was a close call when we were preparing for our defense. Close call is this, Judge. If we open the door, then maybe some of your prior rulings need to be revisited about what statements Mr. Lawson made can be used.
Judge, we can't
This
do
was
that
a-
at this
Listen,
point.
I've ruled on this issue.
I get it.
I have no problem you saying he's been interviewed, but we're not gonna get into what was said during the interview.
I didn't say that.
Yeah, okay.
Yeah.
Judge, he's just
He's
alluded to
just
the
told
fact
us
that
that
we've
we've
interviewed him
we've
over
been
20
interviewed.
hours.
No, I didn't even say that. I said
he said
you've interviewed him 20
20
times.
20 times.
And it's a true statement.
But it,
I'm not going to say what he
We
said.
have no ability to combat that unless we can deal with the interviews.
Let's move on. I've made a ruling previously. We're gonna stick with the rulings that the court's made, okay?
yes, sir.
Yes, sir. Thank you.
Thanks, sir.
Can you turn it off there? Can you turn it, go me to?
What you're going to see is evidence that Mr. Lawson cooperated on numerous occasions with law enforcement, with the grand jurors, with, quite frankly, anybody that wanted to ask him a question, okay? What you're also going to see is that when Mr. Lawson did not state what the Commonwealth wanted him to state, he got charged. But he got charged, and that's why he's sitting. That's what the evidence is going to show. What it's also going to show is that the prosecution, in this case, in an attempt to solve a mystery that many people, including me, want solved, overreached and did things that should never have happened, should never have been done, and in order to get a resolution for the Ballard family and the loss of their loved one. That's what this is going to show. That's what you're going to see at the conclusion of this. You're going to see that we don't have the answers. We don't know where she is. We don't, unfortunately. But Steve Lawson, while he did commit the offense of tampering with physical evidence by, on July 3rd of 2015, go to the Bluegrass Parkway near mile marker 14, excuse me. He did, in fact, meet his son there. He did. And when he got there, his son wanted him to take him away from that location. And he did exactly that. But before he left, Steve Lawson put his hand inside that vehicle and manipulated the seat. When I say manipulated, that's a fancy word for move. He moved the seat. He moved the seat forward. And he moved the seat forward, as you're going to hear, because he wanted it to appear that Crystal Rogers, or somebody that was not his son, was the last person driving that vehicle. You're going to hear that. You're going to hear that. That lines up with tampering with physical evidence. We're not going to argue that. After you hear all the evidence and you go back and deliberate, and remember, what I just told you, not evidence. Not evidence. What Mr. Young told you, same thing, not evidence. When you hear the people that get in this witness box and they make statements, that's the evidence, okay? When you hear that, myself as well as the entire team is firmly convinced that you will find Mr. Lawson guilty of exactly what he's guilty of, and that is tampering with physical evidence, and that is not conspiracy to commit murder, or for that matter, any harm of Ms. Rogers. Thank you, Your Honor.
Is the Commonwealth ready to call its first witness? Who's your first witness?
Sherry Ballard.
Sherry Ballard.
Will you approach?
You may. Ms. Ballard, you come on up, please. I'll go ahead and give you an oath. You'll raise your right hand for me. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? You'll have a seat right over there, ma'am.
I guess it's a minor point, and I do what I stated in my opening was accurate, and I swear I'm not asympathetic to her. My first question would be, what is she going to be utilized for?
She's one of fact witness.
Is that? Are we still on, or I'm a
You know
little
why
worried?
we're having this noise? Is it that microphone? Then let's put that microphone somewhere else then.
Oh, her microphone.
Okay. I feel like everything I'm saying is amplified here.
It does have an odd feel to it.
Oh, I bet you that's not somebody's white noise. Does it have an off button?
We'll be back in the clerk's office if you come and assist us. Just want to make sure that this picks up what you're saying.
So I'm
You can't hear us out there? No. Okay.
So I'm completely aware that you're not obligated to tell me what she's going to say before she testifies. That's what objections are for. I get it. I just want to make sure, because of my review of the discovery, I don't know of any connection between this witness and Steve Lawson. And I want to make sure that, okay, I want to make sure that there's not going to be any speculation or anything to that effect. And minor point, there was a separation of witnesses admonition, and she has been in the courtroom during the opening arguments. One could argue that that was a violation of the separation. I understand the basis of the separation of witnesses, so witnesses don't hear each other. However, I think in good form, she probably should have been outside the courtroom if she's going to testify.
Just come out by Marcy's law. This is Marcy's, 2 years ago, Marcy's law trumps the separation of interest.
So,
It's a constitutional right.
All right, guys. Let's move forward. I'll move your objection. I think they were right to call. I think I've already heard that she was the person that called the police. So
yeah,
there's
sure.
a factual
I get
basis
it.
for
I get it.
So if there's objections along the way, we'll just take them up.
And great. And with that, before we leave, we never discussed this before. What's your preference on objections? Do you just want me to say it out loud and then we approach? Do you want me to say the basis for it?
You
Probably.
say objection and approach, that's fine. And if it's an obvious thing, I'll say sustain and won't come up here.
Okay, very good. Thank you.
I don't really know where to go to ask her questions, but I guess I'll just go over here.
I don't know when there's a podium. I don't know where people are. We can turn off the white noise. You go anywhere you want. I don't care where you ask your questions
I
from.
just don't want her looking at me and not looking at
Sure.
Sherry, if you'll just answer, look at the jury and answer questions. Would you please state your name for the record? It's okay.
Sherry Ballard.
Well, you're gonna have to speak up. Okay, Ms. Ballard. I want to talk a little bit of background with you. Where do you live? Not the address, but what county you live in?
I live in Bardstown, Kentucky.
All right. And you're a widow, is that correct?
Yes.
Okay. And you were married to Tommy, is that correct?
Yes, sir.
And you have children.
I have 3.
Okay. And it's, go ahead and tell me. Who are they?
Crystal, Casey, and Brooke.
Do you have grandchildren?
I have 9.
My great-grandchildren.
I have 4.
Casey and Brooke are still with us, correct?
Yes, sir.
And they each have children, right?
Yes, sir.
Okay, they're both married.
Yes, sir.
And then Crystal, as we talked about, Crystal's deceased, correct?
Yes, sir.
I want to talk a little bit about Crystal. Crystal, the last time she was seen was how old was Crystal?
35.
35. And Crystal was had children as well, correct?
She had 5 children.
And who was that? Who are they?
Ashley, Kylie, Trenton, Tori, and Eli.
All right.
Randy, you have any exhibit stickers? Just one would be fine. Numerical.
Judge, can we approach?
You may.
I know what the answer is going to be, but I'm objecting for the record to the calling of this witness to lay the foundation that he's laying the foundation for. I believe that there are other witnesses that are clearly qualified that can say the same exact things, that are not going to front load the type of sympathy that this individual is getting from this jury. She can't compose herself, quite frankly. And to me, we have fast forwarded to the sentencing. This is a sentencing witness to me, and I get it. I get it, Judge. She is a fact witness, and that's what they've called her for. But I object because she can't compose herself. I think the Commonwealth knew she wasn't going to be able to compose herself, and this is turning into a pity show for Miss Ballard, and I have pity for her as well. But it should not bleed into that jury. If we don't get to sentencing, then what we're seeing here can clearly be portrayed by somebody else that is less emotional and less sympathetic to this jury.
At this point, I don't find that the Commonwealth has gone anywhere near that at this point, so I'll note your objection over at this time. I've got a juror says they can't hear the questions that you're asking, Mr. Youngs.
Sorry?
A juror says they can't hear the questions. I don't know if that podium can move or what.
If that microphone had the podium.
Where did that microphone go? There you go. No, they can't hear you.
Oh, can't hear me? Okay.
They can't hear you.
I got you. Okay. Sorry about that. Oh, I gotta show that here. Sherry, I'm going to show you what's been marked as Commonwealth's Exhibit number 1 and 2, okay? And I want you to take a look at these. And do you recognize these pictures? Okay. And do they fairly and accurately portray what the pictures are?
Yes.
Okay. Could you tell the ladies and gentlemen of the jury what those pictures are?
One of them's a picture of Crystal, and the other one's a picture of Crystal and Eli, her youngest son.
All right. Do they fairly and accurately represent that?
Yes,
Judge,
yes,
I moved to
sir.
introduce into evidence.
Any objection? Okay, I'll show 1 and 2 are introduced without objection.
And Judge, I don't know how to use.
You can give them to the clerk there, or you can give them to the jury if you wish to publish.
Send them to the bailiff to publish
Yes.
to the jury?
We publish to the jury.
There you go. Now, I want to talk a little bit about Brooks and Crystal, okay? Could you tell me, are you aware when they began seeing each other?
Yes, sir.
Okay. And when was that?
gosh, probably 2000, the end of 2010, 2011.
Okay, you want to tell me the beginning of the relationship, how was it?
They had a pretty good relationship in the beginning. She actually rented a house from him.
Is that how they met?
Yes, sir.
She was renting a house from him?
Yes, sir.
Okay. And eventually, did it develop into more?
Yes, sir.
All right. And at some point, did she move in with him?
Yes, sir.
Okay. Was she working at the time?
Yes, sir.
Where did she work?
She worked at a little minute mart. Sorry. She worked at a little minute mart that was right down the street from where she lived.
Okay. And she do that when she was living with Brooks?
Yes.
All right. And at some point, did they move in together?
Yes, sir.
Okay. And when was that?
After she got pregnant with Eli, she was probably 5 or 6 months, I would guess, and she moved in with him.
All right. And did she move in with with Kylie, Tori, and Trent?
Yes.
All right. So they all four lived with Brooks. Is that
Yes,
correct?
sir.
Okay. And was she still married to Keith at the time?
Yes, sir.
Okay. Tell me about that situation.
Her and Keith just didn't get along. They still had a good relationship, but there was things in their marriage that wasn't working, and she left him, and that's when she rented from Brooks, and she never got it. She couldn't afford a divorce. She was going to try to do some stuff on her own, but she couldn't afford it. So she was still legally married to Keith.
At some point, did she quit working at the store?
Yes.
And did she begin working for Brooks?
Yes, sir. She was going to do his paperwork for his rentals.
Okay, and I'm going to take you to July of 2015, all right? So in July of 2015, were Crystal and Brooks still living together?
Yes.
All right. And what was the status of the relationship then?
Not good.
Okay, what do you mean by not good?
She wanted to leave the relationship. Brooks had other girlfriends, and she found out about it, and she wasn't happy with that. And one time, just little things happened. Like one time they were skeet shooting, and he switched out the bullet in her gun for a turkey bullet. I don't know the details. I'm not a hunter, so. And whenever she did it, it kicked back and hit her shoulder and put a big bruise on her shoulder.
So things weren't good in July 2015?
No.
All right. So July 4th of 2015, you remember that weekend?
Yes.
All right. Did you at some point become concerned about Crystal's whereabouts?
Yes.
All right. And what was your first indication, or what was your first indication that something may be wrong?
Because I tried to call her and she never called me back, and she never not returns my phone calls, ever.
Did you hear from her kids?
Her daughter texts me and she's like, Mama, she was at her other grandma's house, and she said, have you talked to Mom? I need some clothes. And I said, no, honey, but I'll call her and tell her you're trying to get in touch with her. So I text my daughter, and I didn't think any more about it. I was actually watching The Young and Restless in my bedroom, and I would tape it all week, and my husband would watch what he wanted on the other TV. And so I didn't think, she didn't text me back, Callie didn't, so I just assumed my daughter got in touch with her.
Let me get a sticker. So you said you texted her?
Yes, sir.
Okay. I'm going to show you what's marked as Commonwealth Exhibit number 3, okay? And I want you to take a look at that. Have you seen that before?
Yes, it's my text message to my daughter.
Okay. Could you go ahead and read those for me?
On 7/4, it says Callie is trying to get in touch with you. And then later on that night, I said, everyone is worried about you, even your kids. Call someone.
Judge, does this fairly and accurately represent your all's conversation, or your
Yes,
your
sir.
text to her that weekend?
Yes, sir.
Judge, I move to introduce comments to number 3.
Any objection to 3?
No objection.
I'll show 3 is introduced at this time. May be published to the jury.
So were those texts ever answered?
No, sir.
So Sunday comes around, July 5th. You've not heard anything, correct?
No.
All right. What happens on, what do you do when you get up Sunday?
I'm trying to call everyone I know that my daughter would have talked to see if they'd talked to her, and no one had. And then I start to panic because I know something's wrong. And my husband told me, he said, my son had stopped by from Green River, so him and his wife were there. And I was getting upset and starting to cry, and my husband said, we'll go look for her. Because I told him, I said, no, I'm telling you, Tommy, something's wrong. So he told me to go file a missing persons report, and him and my son went to look for her.
Did you talk to Kylie again? Do you remember?
I don't think I did.
That's okay. So Tommy told you to go file a missing person report, is that correct? So do you go to file a missing person?
Yes, sir.
And does anything happen on your way there?
On my way there, in front of Walmart gas pumps, I passed Brooks' house. So my granddaughter was with me, and I told, not Callie, a different granddaughter, Ashley. And I said, will you please text him, because I was driving, and I said, tell him to pull over. I need to talk to him. So he pulls over, and he pulls into the gas pumps, and I get out of my car and walk to his truck. And I go to the passenger side, and he rolls down the window. And I said, have you seen Crystal? Or have you talked to Crystal? And he said, no. And I said, well, what, did y'all get in a fight or something? And he said, no. She gets in a little tizzy sometimes because she thinks I treat Eli different than the other kids. And I said, but you haven't talked to her? And he said, no. And at that point, the baby stuck his head from around the back seat because he was in the car seat. And I knew the instant I saw that baby in the truck that something was definitely wrong, because my daughter never left that baby, never.
So when you saw the baby, you knew something was wrong?
Yes.
Did you ever see Crystal without the baby after the baby was born?
No, she took that baby to court with her when she used to go. She would take the small claims court, the people that rent it from them, and she took him to court with her.
Okay. Have you watched the video at the gas station?
Yes.
Okay. Does it fairly and accurately depict that?
Yes,
Matter
sir.
of fact, we reviewed that shortly before we come in here.
Yes, sir.
correct? Okay. And does that video fairly and accurately represent that?
Yes, sir.
Okay, Judge, I move to introduce comments exhibit into evidence number 4.
What is it?
This is a flash drive.
Oh, flash drive.
It's going to play in the record. Okay, I just went ahead and made a flash drive.
Any objection to 4?
No objection.
You may. I'll show it's introduced at this time.
Judge, could we put it on the TV? And can I ask Ms. Ballard to come down so she can show everything to the jury?
Yes.
Where she's at. You can come on down.
I think there's a TV right behind her, too.
Oh, okay. Never mind, I'm sorry. We'll come over here, Sheriff. All right, well, I want you to point out, you got to come over to me if you're concerned. I want you to point out, ladies and gentlemen, the jury, so they can see on their TV screen where you are and where Brooks' house is.
That's me pulling in over here.
And I think you said in the meantime you'd had Ashley
And
call.
this is Brooks out coming into the gas station.
In that truck there?
Yes, this truck right here. And that's me coming over to the truck.
Is that you walking?
Yes, sir. And I go to his passenger side window.
And is this where y'all are having the conversation?
Yes, sir. That's when I'm asking him if he saw my daughter.
Hold up, it's on Miss
Oh,
Ballard.
I'm sorry.
That's all
I'm
right.
so sorry. I'm used to it in my pocket.
And you're still talking to him there?
Yes, when I asked Brooks if he saw Crystal, when he told me no, I told him, I said, I'm gonna go file a missing persons report. And he just looked at me like I was talking about someone off the street, and he said, I think that's what you should do. He never offered to go with me. He never offered anything. And that's when we left.
Is that you running
That's
by?
me going back to my car.
Let's take a section. So do you all go to the police station?
Yes, sir, I did.
Okay, did Ashley go with you?
Yes, sir.
Okay. And did your family do some searching for her?
Yes, we started that night, that very same night. We searched till like 3 o'clock in the morning on the BG,
Oh, well,
uh,
the BG.
the Bluegrass Parkway. We searched the area where her car was found on the opposite, behind her car, all that.
All right. Did you ever hear from Crystal?
No,
Did you ever find any signs of Crystal?
no,
Did you all have people giving you information?
constantly.
And did you all follow up on it?
Everything, everybody told us we followed up on. My husband told me, Sherry, it might sound, like it's not. You follow everything anybody says. We have to prove that it's not correct.
So, to your knowledge, has Kylie, Tori, Ashley, or Trenton ever heard from Crystal?
No,
All right. Have they been living with you?
yes. They all don't now, but they were.
Right. They're 10 years old now.
Yes.
So, to your knowledge, has anybody, either you, family, friends, anybody, heard from Crystal?
No, sir.
Judge Donovan, further questions?
Any cross?
No, Your Honor.
Ma'am, you may step down, thank you. We've been going about an hour. Why don't we take about a 10-minute break and be ready with your next witness, okay? So the jury may go with the bail. Remember, the same admonitions are in place, okay? That I've gone over previously.
Sorry, it's on this thing, I think. Thank you.
We'll start back at 2:41.